That we are doing so, my lord. My friend is unnecessary wasting time of this honorable court.
No, don't say that because he has his own way of arguing.
Challenge the charge sheet which has been issued to me by the respondent, the commanding officer, my lord.
You are in custody since?
19th of November 22, my lord.
Was it a punishment?
I was serving to the post of rifleman. As per the Army Act, they have taken me into custody.
My lord, he has already applied for bail before the FT. His bail application has been rejected.
My lord, I was just a rifleman who was posted at Military Hospital, Jabalpur. Army Act does not follow CRPC per se. Now, being an army person, you cannot implead me under a special act. And then there is summary court martial that is also under the army rules. But as of today, I am in the custody. This honorable court also that once you agitate a fundamental right, they might end up the court martial proceedings and they might end up fully.
My friend is willfully misleading this honorable court, my lord. Homicide capable, murder and rape. These three offences cannot be dealt with by court martial, my lord.
Criminal offense is called a civil offense. All other offenses can be tried
By court martial.
Yes.
My lord, in this matter, I have challenged the charge sheet which has been issued to me by the respondent, the commanding officer, my lord. And this charge sheet has been issued to me, my lord, under sections 7 and 13 of the Prevention of Corruption Act, read with the offences of IPC, my lord, 120B. This charge sheet, my lord, is dated 21st of November 22, and I have been in the custody since 19th of November, my lord, till today. I was, my lord, discharged from my services with effect from 31st of December 21, my lord.
You are in custody since?
My lord?
You are in custody since?
19th of November 22, my lord.
22. Why are you in custody?
My lord, what this says that I should be taken into custody because I am not in their active service since 31st of December 21. So they discharged me from services on 31st of December 21. And when the trial was supposed to start, my lord, they take me.
Discharge means by what means?
My lord,
Was it a punishment?
the trial for
No, discharge.
discharge, my lord, was because of I was declared as a low medical category because I was suffering from seizure disorder, my lord. This order is at page number 27.
This is Army
Army, my lord.
or Navy?
Army, my lord.
Army.
I was serving to the post of rifleman since 2003. Now, my lord,
So you are in custody because of that PC Act case?
not because that as per the Army Act, they have taken me into custody, saying that because you're not in active service, and that is why we are enforcing section 123 of the Army Act, which says that we'll take you into custody and then do a trial over you.
My lord, he has already applied for bail before the FT. His bail application has been rejected. This is not the issue.
123?
123 of the Army Act, my lord, 1950.
Okay.
Now, in this matter, my lord, I am challenging the charge sheet which has been issued to me, my lord, by order dated 21st of November 22.
Where is that?
My lord, this is page number 23. Now, my lord, what I submit is no, my lord, what I submit.
You are part of the recruitment process.
I was not part of the recruitment process, my lord.
Who are you?
My lord, I was just a rifleman who was posted at Military Hospital, Jabalpur.
Achha.
And why I challenge this charge sheet, my lord, is because I am exercising my Article 14 and 21. What I submit, my lord, is that Army Act does not follow CRPC per se. It is a self-sufficient act, my lord. Now, being an armed person, you cannot implead me under a special act until unless you read that act in its entirety. Now, my lord, the Prevention of Corruption Act is very clear when we read Section 4 and Section 19. Section 4, my lord, says that notwithstanding anything contained in the CRPC or in any other law for the time being in force, the offences specified under subsection 1 of Section 3 shall be tried by a special judge only. Now, when you bring Section 7 and 13 over me, my lord, it is only the special judge prescribed by the Act who can try me. Over here, my lord, you issue me a charge sheet on 21st of November 22. You initiate a trial over me by a general court martial, my lord. That is also under the Army Act. Now you initiate the trial over me without giving me a sanction under Section 19. It says that prosecution sanctions is necessary to be accorded.
No, that is not under challenge here.
It is challenge. There's a specific judgment on this point, my lord, which says that whenever an army man is prosecuted under the special act, it is necessary that the procedural safeguards guaranteed under that special act has to be followed. Well, this is judgment I'll just read out before my lords.
What is the citation?
My lord, citation is 2002, 9 SCC, page 73, my lord.
Like,
I passed the printouts, my lord.
yes.
May I point out, my lord? This is paragraph number 15, my lord. The facts of this case was that an army man was prosecuted under the NDPS Act, my lord. He went to the court saying that the procedural safeguards have not been accorded to me of the special act. Because, my lord, when an army person is prosecuted under a civil offense, which are these special acts, they can only reach the special act through Section 69 of the Army Act, which says that how to prosecute an army person in special acts through Section 79, which is of the Army Act, my lord. So, my lord,
When you say special act, you mean what?
Special act, my lord, for army persons, the special act in civil offense would be any act other than the Army Act, which is the Prevention of Corruption Act.
Prevention of corruption. No, but this charge sheet that you are challenging,
yes,
is a charge sheet issued in a disciplinary matter.
No, my lord, it's a criminal offense, my lord. It's a criminal trial which is going over me, my lord, under the Army Act.
It's a criminal trial.
Yes. So, my lord, what they do is that a general court martial has been accorded the status of a criminal court. A general court martial is constituted, and then a person is tried under the general court martial. That is what they have been doing under me, my lord, and they prosecute me under the special act, but they do not follow the procedure guaranteed to me under the special act. That is where I agreed under Section 14. And when the question of law is enforced, my lord, I am under their custody since 19th of November, my lord.
And where is that provision in the Army Act
Uh,
empowering them to
Take me under custody.
and this issuance of charge sheet?
Yes, my lord. My lord, when they take me under custody, my lord, that is Section 123 of the Army Act. Married, my lord. Where an offence under this act has been committed by any person while subject to this act, and he has ceased to be so subject, he may be taken into and kept in military custody and tried and punished for such offence as if he continued to be so subject. So under this, my lord, they take me into custody and prosecute me for these offences. Now, where I get aggrieved, my lord, is when you read Prevention of Corruption Act just for the substantive part, my lord, and you do not follow the procedural part. And this is where, my lord, this judgment I've just cited comes in. Para 15.
Yes.
Para 15 says, my lord, turning attention onto the procedural aspect, be it noticed that section 18 is an offence which cannot be described to be civil in nature in terms of the provision of the Army Act. If section 18 is to be taken into recourse,
Section
then
18 of
the NDPS.
NDP. Yes.
And then in that event, the provisions of the statute come into play in their entirety rather than piecemeal. The charge leveled against the respondent is not one of misdeeds or wrongful conduct in terms of provisions of the Army Act, but under the NDPS Act. In the event we clarify a particular statute is taken recourse to.
But where are such charges here?
Well, charges?
Yeah, there are no criminal charges.
No, my lord.
These are charges relating to your discharge of duties.
No, my
as a
lord.
rifleman.
No, my lord. Page 23 is a charge sheet.
Yes.
Which says, my lord, committing a civil offence, my lord. This is civil offence they read in the Army Act. That is to say, being a public servant obtaining undue advantage from a person with the intention to cause improper performance of public duty contrary to section 7 of Prevention of Corruption Act. The charge 1 is under 120B, my lord, and charge in the next page, my lord, page 24, it is 7 and 13 again.
7 and 13, where does it say so?
My lord, I will just read out section 69 of the Army Act, my lord. Just clarify the doubt. Very well.
Yes.
Now, what the procedure in the army is, my lord, when they have to implead any person outside the Army Act, they read section 69 first, which says that civil offences. Civil offences means which are not punishable under the Army Act, my lord. Subject to provisions of section 17, any person subject to this act who at any place in or beyond India commits a civil offence shall be deemed to be guilty of an offence against this act, and if charged therewith under this section shall be liable to be tried by a court martial and on conviction be punishable as follows, that is to say, my lord. Now, my lord, what this the way in the manner they implead an army person under a civil offence which is not punishable under the Army Act, they say that civil offence section 69 contrary to that particular civil offence, which over here in my case is section 7 and 13. So that's how a charge sheet is issued to me, and the trial has commenced over me on 10th of December 22. Now I come in, my lord, agitating on the point that you cannot try me under the Prevention of Corruption Act. It is only the special judge who can try. Section 4 of the Prevention of Corruption says, my lord, notwithstanding anything contained in any other law. So Section 4 becomes supreme to Army Act also, my lord. That is what my primary agitation is. Thereafter, my lord, I ceased to be a public servant with effect from 31st of December 21. And lastly, my lord, which is section 19. Section 19, my lord, it says that previous sanction necessary for prosecution of the Prevention of Corruption Act, my lord. My lord, the moot point which I want to agitate is that being an army person, am I entitled to the procedural safeguards or am I not entitled to the procedural safeguards of a special act, my lord? That is what the moot point is. If you want to prosecute me under prevention of corruption, accord me a previous prosecution sanction. Let me be tried by a special judge. And when you try me under the Army Act, my lord, the Army Act is a self-sufficient act. That is what the object and reason say so. And Army Act itself provides for the offences when the person is, which is section 53, my lord, of the Army Act. It itself provides that you can prosecute an army person when he is involved under the offences of corruption. You don't implead me under section 53 of the Army Act. You use 69 and come into the domain of prevention of corruption. Do not accord me a procedural safeguard and start trying me, my lord. I would also, my lord, with permission, just read out the statements and objects of the Army Act, my lord.
What about section 123?
123, my lord, says that they can just try me when I'm not in service and take me into the custody, the military custody.
And the trial has to be as if you were still in.
They can try me.
So that means the Army Act comes into play.
Army Act comes into play. I do not agitate on their part. I just say that you cannot try me under prevention of corruption because of, by virtue of section 4, because that is the non-obstantive.
Who is conducting the inquiry right now?
My lord, what happens is that inquiry is not being conducted. As of now, my lord, a GCM is constituted, the court martial is constituted, which is constituted by the army officers only and presided by the army officers to the rank of colonel and so on, my lord. So basically, it's sort of a jury system where 5 members sit and a trial is commenced on the accused. So that general court martial, my lord, has started on 10th of December, 22.
So had you been in service,
I had been in service.
then the same procedure would have been followed.
Yes, my lord.
But that is what they are doing, I think.
No, my lord. But when they try me under prevention of corruption, my lord, they are hit by section 4 because that is supreme to army law.
No, they are not trying you under the PC Act.
No, they are trying under the PC Act, my lord.
No, they may have mentioned those sections, but the procedure to be followed is the General Court of Martial.
No, my lord. They are trying me specifically under the Prevention of Corruption Act. The substantive law they are following is Prevention of Corruption Act only, my lord, section 7 and 13. And this happens, my lord, without according the procedural safeguard. That is where I get aggrieved, my lord. And lastly, my lord, the offence pertains to, as per the charge sheet, which starts on the 4th of May 2019, my lord.
Yes.
For more than 3 years, they do not do anything. They conduct their procedures as per the Court of Inquiry, as per the Army Act. They issue me a charge sheet on 21st of November 22, almost after 3.5 years.
After that period of 3 years.
After the statutory period of 3 years, that is section 122 of
123(2)
of the Army Act, my lord. I'll just read, my lord.
Unless his trial commences within a period of 3 years after he had ceased to be subject to this act. When
Yes.
did you cease to be?
My lord, I ceased to be a subject on 31st of December 21.
21.
Yes.
So it's 3 years have not elapsed yet.
My lord, the period of 3 years has to be initiated as per 122 from the date of offence, my lord. My lord, we see 122. Except as provided by subsection 2, no trial by court martial of any person subject to this act for any offence shall be commenced after the expiration period of 3 years, and such period shall commence on the date of the offence, where the commission of the offence was not known to the person aggrieved by the offence or to the authority competent to initiate action, the first day on which such action come into the knowledge of such person and authority, whichever is earlier. So, my lord, the date of offence, as per the charge sheet, my lord, may see page number 23, is 4th of May 2019. This is the second paragraph.
11th of October 19.
Between 4th of May 19 to 11th of October 19.
Yes.
So the period of limitation anyway would have expired in October 23, Malur, 22, Malur. And the charge sheet and the trial starts in the month of December 22, Malur. That is one of the aspects to this, Malur. But my primary agitation is with regard to the procedural safeguards only, which has not been accorded to me by virtue of the Prevention of Corruption Act. This LD Balam case, Malur, I had just pointed out, is very clear on this aspect that an army man is required to be given a procedural safeguard.
All right, so that's all.
Well, I would just want to read the relevant part of this judgment. I'll just read briefly material lines.
Para 15.
Para 15, Malu.
Hmm.
I'm reading from the C part, Malu, where needless is there, Malu. Needless to record that there were two other civilians accused who were tried by the court at Patiala, but were acquitted of the offence for non-compliance with the mandatory requirements of NDPS Act. Once the petitioner was put on trial for offence under NDPS Act, the General Court Martial and the Army authorities cannot reasonably be heard to state that though the petitioner would be tried for an offence under Section 18 of the NDPS Act, yet the procedural safeguards as contained in the statutory provision would not be applicable to him being a member of the armed forces. The Act applies in its entirety irrespective of the jurisdiction of the General Court Martial or other courts, and since the Army authorities did not take into consideration the procedural safeguards as are embodied under statute, the question of offence offering any credence to the submission of the Union of India in support of the appeal does not and cannot arise. So this is what, my lord, I'm trying to portray before my lords, that same procedural safeguards is also accorded under the Prevention of Corruption, which has to be given to me. Compare me with a civilian who would be given all the prosecution sanctions, and I will not be given any prosecution.
What have you challenged before the tribunal?
My lord, before the tribunal, my lord, that was the OA in 21 that has become infructuous when the charge sheet was filed. That was the intermediary phases when they were conducting their internal inquiries as per the Army Act. That I'm orally making a submission that when the next sitting is there, my lord, we will anyway be withdrawing that OA, my lord.
What is under challenge there?
My lord, over there, my lord, there were intermediary phases of court of inquiry, my lord. So when a person is to be tried in the Army Act, my lord, who is subject to that, there is a first provision of court of inquiry, my lord, that is under the Army rules. And then there is summary court martial, that is also under the Army rules. So while this stage was going on, my lord, these intermediary challenges were made, my lord, against the court of inquiry.
So what you had challenged is 5/11/19 and 7/11/19. The orders were challenged, by which inquiry had been initiated.
Yes.
Inquiry means what? Charge sheet was issued to you?
No, my lord. Charge sheet was issued in November last year, my lord. This was the intermediary phase which they have to follow before issuing the charge sheet.
So that you challenged?
That you challenged, my lord, that will withdraw because once the charge sheet is filed, all that become infructuous.
You've not yet withdrawn that?
we have not yet withdrawn it, but we are withdrawing it, my lord, because the AFT is not sat.
Subject matter is same.
My lord, subject.
That is a precursor to this charge sheet.
My lord, but that stages which we were challenged, that anyway will withdraw because that has become infructuous.
Well, fine, but so long as it's pending, it's pending.
Yes, my lord.
Either you show us the order that you have withdrawn it.
We will withdraw it because anyway, my lord, the AFT will not be in session for the vacations. We will file an application for withdrawal, my lord. That is what at best we can do at this stage.
In fact, last time also this objection came up from the other side. You were required to amend and inform the court about
that we have
pending.
My lord, that was amended and we have informed the court about it, my lord, that it is still pending.
So then why should we entertain this petition? Because it's pending there.
My lord,
either you withdraw it and then come.
My lord, but I will withdraw it, my lord. But as of today, I am in the custody. That is where I am primarily agreed as of today, my lord.
No, fine. But this particular grievance can be raised in the tribunal also.
My lord, when I agitate my Article 21, my lord, under 226, I can bypass Section 14 of the AFT Act and directly come here, my lord. That this matter is no longer res integra, my lord. This has been held by this honorable court also, that once you agitate a fundamental right, you can directly come under 226. You need not wait for the tribunal to order for that, my lord.
There is no bar as far as 226 is concerned. Yes, there cannot be.
Yes.
But as a matter of prudence, as a matter of, not as a matter of bar, but as a matter of policy, we say that you first exhaust the remedy available. The remedy that you have already availed.
Yes.
You should either withdraw it or exhaust it.
My lord, if I may submit, what if my lord may entertain, keep it day after tomorrow, we'll file an application for withdrawal tomorrow itself. And because he's in military custody, that might take one day. We'll take his affidavit and then we'll file it tomorrow itself. My lord, we'll keep it day after tomorrow. My lord.
Will you be able to do that?
My lord,
such a short time.
We will do it, my lord. Because, my lord, once the vacations start, they might end up the court-martial proceedings and they might end up full.
We'll take it up on 11th.
Even if he withdraw that original application over this, still jurisdiction does not lie with all respect before this honorable court. My lord, may allow me to address what is under challenging. My friend is willfully misleading this honorable court, my lord. My lord, the seminal issue that has emerged for consideration of this honorable court, whether any civil offence committed by defence personnel are triable by the court martial or not. I will read only one section. PC Act itself, by virtue of Section 25 of the PC Act, we are under the well within jurisdiction. We are doing this, my lord. Well, Section 25 of the PC Act, my lord, says jurisdiction exercisable to Section 25. We are exempted, my lord, from this act. May I read from Section 25? My friend is wasting time of this honorable court, my lord.
Yes.
Nothing, military, naval, and air force or other law not be affected. Nothing in this act shall affect the jurisdiction exercisable by or the procedure applicable to any court or other authority under Army Act, Navy Act, Air Force Act, Border Security Force Act, Coast Guard Act, and National Security Guard Act. You know, the bar of Section 4 of the PC Act will not come in a way of Army Act, Navy Act, Air Force Act, Border Security Force Act, Coast Guard Act. Unnecessary, my friend, is wasting time of this honorable court, my lord.
My lord, what?
And my lord, what are the civil offences? If my lord may come to Section 69 of the Act, my lord, the Army Act, my lord. All kind of civil offences can be tried by the court martial except 3 as given Section 70 of the Army Act. Those 3 are, my lord, homicide culpable, murder and rape. These 3 offences cannot be dealt with by court martial, my lord. If I can take, my lord, Section 63 of the Act, Army Act, my lord. 69, my lord, sorry, 69. Mary?
69.
Yes, ma'am. Civil offences. Subject to the provision of section 70, any person subject to this act who at any place or beyond India commits any civil offence shall be deemed to be guilty for an offence against this act, and if charged therewith under this section shall be liable to be tried by court martial.
So a criminal offence is called a civil offence
Yes, my lord.
in the army.
Yes, my lord, because he has been charged.
It's a very strange thing.
Yeah, my lord, he has been charged under section 69 of.
Anyway.
Yes, my lord. Yes, my lord. We have been given liberty, my lord, by the act itself. My friend is not reading 25, reading only 3 and 4.
My lord, the connotation which has to be seen is section 25 unlimited.
Well, let her complete.
Yes, my lord.
Yeah.
Now I am coming to 70, which we cannot try, my lord. 70 says, my lord, a person subject to this act who commits an offence of murder against a person not subject to military, naval, and air force law, or of culpable homicide not amounting to murder against such person or rape in relation to such person shall not be deemed to be guilty of an offence under this act, shall not be tried by court martial unless he commits any offset offences. Except 3 offences, my lord, we have been empowered to try with, my lord. We have been well within our jurisdiction, my lord. My friend is only taking plea of PC Act, my lord. By virtue of PC Act, we cannot try him. PC Act itself given exemption to the army, defense personnel, my lord. They can be tried under the Army Act. What remains? Nothing is there, my lord. Now he's challenging the charge sheet. This jurisdiction lies before Armed Forces Tribunal, my lord. If he is aggrieved by a GCM proceeding, the jurisdiction lies before AFT, my lord.
How does 70 come into picture?
Remember, any 3 offences which has been given in 70, we cannot try.
Which are those 3 offences?
These, my lord, yeah. Culpable homicide, murder, rape.
Okay.
It is written in here. Except 3, my lord, all can be tried by court martial. And say, I would like to, my lord, read to 28 of section 28 of the PC Act also with the permission of my lords. Yes, the act says, my lord, act to be in addition to any other law. The provision of this act shall be in addition.
So according to you, besides these 3 kinds of offences,
Yes.
all other offences can be tried
By court martial.
tried
Yes.
by you.
Yes, yes. That we are doing so, my lord. My friend is unnecessary wasting time of this honorable court.
No, don't say that because he has his own way of arguing.
He's well aware of this
Maybe
fiction, my lord.
his argument,
This fiction, my lord.
his argument may be against you, but that does not mean that
He can approach the AFT, my lord.
that's fine. This point has not been decided earlier.
No, my lord, not on the prevention of corruption part, but on the NDPS part, I just read out now.
And what about 25 of the PC Act?
My lord, that has not been settled. We tried to search a lot about it. Now, the connotation that we are able to see that 25 is not unlimited. 25 also becomes a law for section 4 also, my lord. Because section 4 says any other law. So what we say, my lord, is that you try me. I don't say that you don't try me, but at least give me all the procedural safeguards. You read section 4 also and section 19 also. And we still agitate, my lord, that section 4 is drafted by the legislature in such a manner that it is even supreme to section 25, my lord.
Well, there are few judgments, my lord, which have dealt with this issue, if my lord may allow me. Okay.
What we say is, he cannot exercise section 25 in violation of article 14 and 21.
All right.
My lord, just few, if may, my lord, first I read 2019, volume 7, my lord.
These are all, these are about alternative remedy.
No, my lord. On the issue whether army personnel can be, if any civil offences can be triable by the court martial or not. My lord, I have marked the paragraph. If my lord will permission, I will read, otherwise, these judgment deals in the same issue.
Now, you mentioned the paragraphs.
I have mentioned, my lord.
Yes.
There are three judgments, no? One is on the question of 123, whether the individual who has been seized to the act can be tried. Second is civil offences can be tried by the court martial or not.
Hmm.
Third is also on the same issue.
What you have challenged in the tribunal is a show cause notice.
Interlocutory phase, my lord, that was the,
Is it a show cause notice or what?
no, my lord, this was challenging the court of inquiry. This is done under rule 177 of the army rules, my lord.
You know, what is
70?
177, my lord.
Hmm. 170.
177, my lord.
77.
May I read, my lord?
Hmm.
Courts of inquiry. A court of inquiry is an assembly of officers or of junior commissioned officers or of officers and junior commissioned officers, warrant officers or non-commissioned officers directed to collect evidence and if so required to report with regard to any matter which may be referred to them. The court may consist of a presiding officer who will either be an officer or a junior commissioned officer and of one or more members. The presiding officers and the members of court may belong to any regiment or corps of the service according to the nature of the investigation. A court of inquiry may be assembled by the officers in command of any body of troops, whether belonging to one or more corps.
Hmm.
So when they initiate the proceeding, my lord, they initiate through 177. And thereafter they follow further procedures, my lord. So this was in the year 21
So
when
this court of inquiry is followed by court martial.
a summary
martial.
court martial,
Court of inquiry, just like a preliminary inquiry.
So preliminary.
preliminary inquiry, sort of preliminary
And
inquiry.
we call it in the civil
Yes.
Yes,
parlance that.
yes, my lord. And then there is a procedure of summary court martial. And
So
after,
court of inquiry is only to find out whether we should proceed ahead against the officer or employee or not.
no, my lord, what the act say,
Whether it's a fit case for issuance of a charge sheet
no, my lord,
For-
collection of evidence, my lord.
for general court of court martial.
My lord, the rules say it is just for collection of evidences,
For the purpose of
for the purpose of whether to proceed or not to proceed.
to issue a charge sheet or not.
That is for the deciding authority whether to proceed or not to proceed, my lord.
My lord, definition of civil offences is given, my lord, in section 3 of the Army Act, my lord.
So you have not yet withdrawn that. What is the OA number?
My lord, this is OA number 106 of 21. my lord.
Already. We will decide. Reserve.